The big thing for me as a HR manager when the Equality Act came out is a very good reminder. It's good to refresh yourself on all the discrimination and harassment issues. But as an employer, you are responsible for the actions of your employees, and the control you have over them is sometimes limited, but you have to do your best. The Equality Act is again saying it's going to be unlawful if you discriminate, harass or victimise any of your clients, and a client becomes a client as soon as they approach you to maybe do some business with them. So, call centres, one of my companies has a call centre, and if one of my customer service assistants puts the phone down after having a conversation with a very strongly accented individual client and then makes a comment in the general office, and a client is actually on another phone line to a different customer service, but they can overhear, because you can sometimes hear conversations in the background, can't you? There's a possibility there. It's an intimidating and offensive environment. So your clients have the same protection as your employees. Are you thinking of something in your workplace? You have, and it's a worry, isn't it? So I'm going to go on to how we can try and address that and prevent ourselves. But everything you learn about protecting your employees, think about protecting your clients. And the reasonable adjustments obviously has been there for a while. Certainly the whole hotels having to provide ramps to get into facilities, it's the same kind of thing. But also it goes the other way. I've got my little picture of a traffic warden, and I was thinking of NHS and I was thinking of police officers. You've got, as an employee, you've got responsibility, you've got a duty of care for your employees, and they're out there doing the business that you pay them for. But then if they are being harassed or victimised from the outside world while they are in your care, then you have got that obligation as well. And that's quite scary, depending on what kind of business you're in. It's no different from having your normal duty of care, and if you've got grievance procedures and you've got good line management, you can get on top of it. But you've got to have a think about how far you're going to go with a client that consistently harasses one of your members of staff. Say a bank clerk in the window, someone comes in every Friday to pay in their wages, and there's always some kind of nasty or vindictive comment because of the way that the bank clerk has got his or her hair or earrings, or I don't know, got a pierced nose, and if there's banter but it turns nasty and that client is coming in every Friday, what are you going to do as a manager or as an employer to protect your employee from that? But law can get people very very concerned. Essentially the Equality Act, there was a bit of a hoo-ha when it came out, and then everyone pretty much relaxed. It wasn't that shocking, and most things will already be in place. We've all changed a lot over the last 20 years, I'm sure, in business. There's still a few tweaks from some old school management. You've probably got your experienced some of that, where people are still pushing the boundaries, but the protected characteristics are still the same. So if you know those, you know the areas to be thinking about when you're making decisions in the workplace. The associative discrimination is one to try and to get your head round before making decisions. You're going to be taking into consideration, is this a possible association, or is this a perception, or is this possibly an arising from disability? Is there anything going on behind the scenes? And the disability 8 capacities, I could see this going one way or the other, but I think it's going to have more claims coming forward, more people that will be able to prove that they have just that simple statement, which is long-term adverse substantial effect on day-to-day activities. This third-party conduct and the asking about health prior to employment and your responsibility for how your employees act to your clients, those are the things that for me as a HR manager I'm actually taking most care over going back to the workplace. But let's talk about practicalities. It's all about less favourable treatment, and the first thing to think about is actually, do you ever make decisions where you're going to treat someone less favourably than the other? The laws, the discrimination laws that have been there for the last 30 years have kind of got us into the habit of checking ourselves before we make decisions anyway, to make sure that we're not going to face a claim. But it's the first thing that has to be checked. Was there less favourable treatment? And if so, is it connected to a protected characteristic? If it's not, it's unlikely to go much further, I believe. But if it can, in any way, shape or form, be connected to age, disability and so on, what's going to be your defence? And I work backwards, you see. I think about worst case scenario and then I work backwards. But you see, you have got some defences. You've got the positive action defence. You've also got a very handy genuine occupational requirement. Have you heard of that before? Yeah? Or qualification, so it's a GOC or a GOR. When I say GOC, people automatically think about dressing and someone taking you into the changing rooms, and yeah. But genuine occupational qualifications or requirements, and we're going to go into that in a little bit. Statutory provisions, you can't be done for following the law, essentially. So that's a defence if you ever get called. And national security. So positive action in a little bit more depth. I read an article in CIPD banding around the term that it's actually positive discrimination, and there's a lot of debate about whether it is or whether it isn't, but the Equality Act is saying it isn't discrimination, it isn't positive discrimination, and they don't like it to be called that. But it can be used as a defence if you have found yourself in a situation where someone has called you on something that you have done. But it needs to have been a proportionate measure to overcome a situation that you have found, that you have researched, and you've got the proof that you can show you the statistics, records that this situation was quite clearly allowing people without this protected characteristic to get further in your business, or to even get their foot in the door of your business. So positive action, you undertook that to balance the playing field. The example there is changing the design of your advertising, where you advertise, reaching underrepresented groups using different methodology, and certainly changing the way you do your training for promotion. So the weekends away at the Cotswolds Conference Centre may be disadvantaging your females, your families, your the old or the young. It could be anything. So have a think about your promotion structures, and in all cases of your working life and what goes on in your business. Is there anyone that can't get into that, and are they a protected characteristic? Genuine occupational qualification or requirement. This will only be a very good defence, a solid defence, if you had identified it a long time ago. You can't put in your bundle of papers at tribunal, oh, by the way, yeah, we found that this to be a genuine occupational qualification. That was the reason we chose this person over that. It needs to have been identified way before, usually at when you're either identifying a role, in terms of having made choices about selection. This is mostly the example. So when you design a new role, or you're looking at updating a role ready for recruiting, you'd be looking, are there any genuine occupational requirements here which will help me justify why I'm going to be choosing one person over another. The tribunal will also be expecting you to have in place some kind of methodology whereby you would be updating those GOCs regularly. It's not something that should be set in stone, because things can change. And it's got to be proportionate. So the actor example, we had a bit of a debate over this back in the office. You could choose, you could turn down perhaps a person of mature years if the role that you're wanting them to play is maybe an 11-year-old or a teenager, but perhaps you wouldn't be able to turn down a 20-year-old to play the part of a 50-year-old because of the old makeup and talcum powder in the hair. So think things through, and if you have situations where you know you're going to have to make difficult choices at selection, then you need to be thinking about what's going to be the genuine requirement that I'm going to fall back on to use that. Statutory provisions. It's bothered me for a very long time about redundancy pay. People with the same length of service but 2 years age difference, one will get an enhanced, well, not an enhanced package, but more money through the statutory redundancy pay. National minimum wage. Obviously, if you get an 18-year-old taking you to tribunal over equal pay, the statutory provision is there so as your defence. The A8, I don't know whether you have anything to do with foreign workers coming over, but the A8's finishing in April. National security, I couldn't come up with much on this. A defence that you would use if you were taken to a tribunal because of a less favourable treatment you had made, a discrimination that you had committed, and you would stand up in the tribunal and say it was because of national security. So I'm not sure about that one, but someone helpfully said maybe Queen's protection, they might have some strict rules about who they can and cannot choose. I don't know. If you know anyone who works with the Queen, let me know, because I think she's coming to Stratford today. We can ask. Now, I didn't have reasonable steps on those list of defences to start with, but this is my personal choice for a defence that's worth its weight. You're going to be asked to explain possibly the actions of your employees who have perhaps harassed, not purposely, but just because of the normal office banter. Someone has taken umbrage and has gone and taken it to tribunal. As an employer, you're responsible. And as a HR manager, my first thoughts is I want to get everybody trained and signing to say that they understand what is and isn't acceptable. And when you do that, no matter what happens down the line, you'll be able to pull out that piece of paper and say, as an employer, we did everything we possibly could to ensure that this was kept as a non-discriminatory workplace, a safe place to work, a fair place to work, and so on. When you do the training, I don't know whether you have this in your workplace, but just issuing a document via email and saying, please read this, you should read this, that doesn't tend to work sometimes by experience. Having them sit down and face to face can work a lot better. And even if you are sending out strict changes that you may have to do to fall back on, don't forget to read receipts on your emails, so it's proof. If you ever do get taken, and it will be under the Equality Act, it is actually up to you to prove that you didn't do it. The employee doesn't have to do pretty much at all, but it's the burden of proof comes onto the employer. So records and dates and refresher training. Don't let it go too long before you get them all in again. Provide biscuits. Employers don't tend to like to come to the same training more than once because they can still vaguely remember it from last year or last 6 months. But it is worth doing. Make it part of your culture, essentially.